trade or business. The term trade or business includes the performance of the functions of a public office. In other words, the governor, the sheriff, the chief of police, the mayor, whoever it is, if they say they carry a public office, it's the same as a trade or a business. They are doing business. Whenever they are doing business, they give a mask that they're God by carrying this title of public office. And people just think it's something special, like a golden shroud. It's not. It's just business. And because of that, they're doing business as name, aka the trade or business, during their performance of the function of that public office. The public office is that trust called the sheriff department, called the governor's office, called the mayor's. But the trade, within that performance, is their badge number and their ID, or whatever name and position they hold. The equivalence in your end is, and so long as within 14 days of that offer, you respond to it, plus proof of service. The clerk must then enter a judgment. Simple as that. In other words, what this is telling you is judgment in the case is not restricted to the discernment or the decision of the acting judge. That name that you're using that's not the litigants is the authorized representative in the interest of that trust, aka the estate of that trust, because estate means interest. And that interest, aka estate, is the ens legis. So now you've privatized ens legis so that you can bring private right of action.
So you should.
Within language of that legislation, they say that, and remember, the schools and the board are public governmental entities. Within the language of it, they will say so-and-so or parties can bring private right of action based on this, or this is the limitation of the private right of action, or this is the amount that will be liable for to sue if a private right of action is to be brought against the school. So that's just one example. So if you're dealing with a public entity that you intend to sue, somewhere within the legislative language that governs them or their liability, such as the Tort Immunity Act. That's the reason why I mentioned the Tort Immunity Act, whereby there are certain public entities in legislative languages that says you can sue us if you bring private right of action, or you cannot sue us if you bring private right of action. Regardless of whether they say that or not, they have no way out, so long as you're using the Constitution. Because of public scrutinies, the Constitution exists to limit public entities. That's the reason why you would always bring the Constitution. These legislatures are just them lobbying the Congress to create things that favor them. But even then, there's always a way out for you, which is always the Constitution.
I'm looking at the Administrative Procedures Act, and it defines the word person as a private or a public organization. So would it be best practice to pair this the sovereign tort claim, whatever act you just recited, with the APA Act?
So the administrative,
literally.
Yeah, I get what you're saying. So the Administrative Procedures Act, so they're different. So the different types of law. There's public law, there's private law, and there's administrative law. Administrative law is a type of law that any entity, use to govern themselves internally and does not apply to you. I think this word public and private confuses people because whenever public law is created, it is meant to apply to everyone. But when it comes to being sued, you are considered private. So depending on the circumstance, you can be private or public. As far as they're concerned relating to you, they are private to you and you are private to them. Administrative law is meant to apply to them and their employees and how they solve things. But remember, if they can do that administratively, that means they took that from somewhere, which is a higher version of enforcement, which is what you always have. So yes, you can, but it probably wouldn't benefit you to cite Administrative Procedures Act, because the thing with Administrative Procedures Act is it allows arbitration, and arbitrations don't use Constitution. So there's a slippery slope when you start to evoke Administrative Procedures Act. Now, if you were in a court case and you intend to evoke as a defendant, and you intend to evoke Administrative Procedures Act, you do it in a manner that, like, altogether, a private right of action means a private person's ability to legally enforce their right upon other people or even organizations. So even if they put some Tort Immunity Act or some form of sovereign immunity, whatever clause, that does not annul your ability to hold them liable. That's where the loophole of knowing legality of thing comes in. They will bring stat, because the two main power that they have to limit you is based on time and based on clauses of saying, if you don't do this a certain way, something is wrong with you, therefore you don't have the right to do it. Time is the statute of limitation, which will show many ways to kill that. Discovery rule, equitable tolling, so on and so forth. The other scrutiny of clauses and things like that is, okay, if you associate with us, meaning rather, the relief sought is correctly viewed as a refund. In other words, restitution. To restore. When you refund something, you're restoring something. The return of monies to a person who overpaid because the original payment was in violation of the law. See this right here? Say, for instance, while restitution may be available in both cases at law and in equity, the concept of restitution and damages are quite distinct. Remember, I read about tort immunity that says if you're bringing anything other than damages, that's when tort immunity does not apply. If you bring in damages, tort immunity applies. If you bring in anything under the damages, such as contract, which was just shown, tort immunity does not apply. That's because restitution and damages are distinct. I implore you to go over in administrative law proceedings, which is arbitration mediation. The government seeks to compel individuals to comply with rules and regulations, not laws, but rules. Rules are created by entities to regulate their entities. Regulations are created to regulate their own entities, established by government agencies, for us, by us. Civil law, and this is the same thing as the Federal Tort Claims Act court. So a lot of people see the Federal Tort Claims Court and they think because it has the word tort in it, that that's where to go. No. Federal Tort Claim Court is an administrative court for the United States agency. And in the Tier 4 questions that I posted a few days ago, I explained that in one of the questions. And the third, civil law proceeding, which are the focus of this action, are used to force compliance, which is what you are doing, are used to force compliance with either public laws or private contracts, and to establish the liability and amount of monetary compensation that must be paid to compensate for injuries. Civil law proceedings can be brought by private citizens. This is what you are doing. Corporations and the government. You can do it, they can do it. But they can only do it because you have the ability. Remember, just like the 14th Amendment reiterates the 4th and 5th Amendment, because it's how they do it in corporation. Whatever you have, they try to tag along with it to say, we can have it too. You can't just have the power, right? The key distinction between civil and criminal law is that civil law proceedings cannot, because contract is based on first in time. And the first in time contract before you physically show up is based on your challenge of all the different types of jurisdiction by a constitutional challenge.
Okay, I get it. So just showing up.
But status report can also be done separately, where you show what your intent is as to what you want to do, whether you've already sent a settlement offer to them or not, because you can set a settlement offer before anything starts. Whether you've already sent discovery, which you can do before anything starts. So you would do a separate status report. Now, if you're dealing with an attorney that don't mind doing that, then it's just really just a regular conversation over the phone. You know, it's kind of like an interview where they say after the interview, they ask you, the HR department asks you, do you have any more questions you want to ask me? These attorneys might not ask you that, but in engagements like that, which I think is really what you're asking, is that what kind of questions do you ask them? Like an interview, you're supposed to ask, well, is this raised or this pay rate that I'm getting based on inflation, is it an inflationary rate, meaning that as the inflation increased, will my pay increase with it? These are the questions that you're supposed to ask during an HR interview for work. That way you don't go broke as the economy is being broken. Well, with these meet and confers, the question you're supposed to ask him is how. The complete 2.5-hour video is on the Patreon page. Take care. Best of luck.